Welcome, friends. As usual, our remaining part of the proposed amendment of IBBI, and welcome to our this webinar series. As usual, our good friend Amit Gupta is today there, and of course, our own Jasveen is presenting the presentation. Amit need not need any introduction. He has come to our program many times, and he is very well known. But for as a formality, I like to mention that introduce formally Amit. Amit is a fellow member of ICSI and also IP professional himself. He is into field of corporate for last 22 years, and it's providing advisory service for complex legal and corporate legal issues. He is also, as regards the professional service, he was also active in ICICI. He was member of Northern India Regional Council, ex-officio member of Lucknow chapter, of member of Lucknow chapter of NIRCICI.
I think we can skip that. Everybody knows that, and let us focus on.
Yeah. So then, yeah, Amit, welcome. Nice to be having you here. And let's start the session. Jasveen, you can start sharing the screen, and we can go ahead. Just give 2 minutes brief on what we discussed last time and start. Okay.
Sure, ma'am. Sure. I'll do the same. Good evening, everybody. It's a pleasure to have all of you again. And with such esteemed panelists, it's an extreme pleasure. I'll just take a quick review of what we had discussed about the amendments last time. So we were discussing the MCA notice dated January 18, 2023, wherein certain amendments had been proposed to be made in the IBC, and we were having a deliberation on the same. So the broad areas and categories of the proposed amendments are in the use of technology in the entire IBC ecosystem, alterations to the admission process, admission of CIRP applications to make it a more expedite process and a more streamlined process, basically. Third is streamlining the insolvency resolution process, which had several subcategories, and we were discussing this particular category of amendments. There is also a proposed amendment in recasting the entire liquidation process to make certain substantial changes that they have proposed in the liquidation. And last was the role of service providers and other stakeholders in the IBC ecosystem. So, like I said, we were discussing streamlining insolvency resolution process. I'll just skip to the slide that we were taking up and where we had stopped last time, so that there can be a link in the continuation. Yes, so last time we had discussed intermingling of the assets of the corporate debtor and its guarantor, wherein it was stated that in case the assets of the corporate debtor and the personal guarantor is closely interlinked, there may be an amendment to, they had proposed an amendment that these assets would be consolidated and would be interlinked to ensure a better resolution. So now we start with the category we are taking afresh, which is resolving interdependent entities. We start here from today for the next set of amendments. So what the notice proposes is that in case where the insolvency process of the corporate debtor and its related parties is being carried out simultaneously, there should be a common adjudicating authority and a common insolvency professional to handle these proceedings. They've also particularly defined the ambit of related party that is there in their vision, which should be limited to the body corporate, which is a holding company, subsidiary company, or an associate company of the corporate debtor, or a subsidiary of the holding company of the corporate debtor. So this is the ambit of related party. So whenever there is a CIRP going on simultaneously, wherein the corporate debtor and the related parties are involved, it would be carried out in a consolidated and a manner where it is more interdependent. Further, they have also stated that the COC of 2 or more corporate debtors may apply to the adjudicating authority to seek cooperation, coordination of the CIRP concerning the corporate debtors. This is in case of specific nature of the two entities. The intention behind this amendment is to improve synergies and ensure cost effectiveness in carrying out the entire CIRP process. Plus, it will also fetch a better value to the assets of both the companies. in line with the vision of insolvency. Any comments on this?
So, Jasveen, very brief comment on this particular point, because this is not something which is new. This is something which is already being practiced. This is the concept of group insolvency. And I believe a similar attempt was made by way of a discussion paper way back in 2018. And unfortunately, the report that came out after that discussion paper, or the outcome of that report, was like it is very difficult to implement at that point of time. So now it's been almost 4 years where we have a practical experience of learning with the case studies of the group insolvency, the challenges, the kind of difficulties, merits, demerits, everything is now on the table. But still, I agree, making a rule for group insolvency may not be a medicine for all kind of disease. Because the challenge what the group at that point of time reported, that the issues are complex. So outcome at that point of time was left to the discretion of IRP as well as the adjudicating authority. And that is what is being practiced today. Say I am an insolvency professional handling one of the entity. Now tomorrow, one of the subsidiary company also comes into a insolvency process. And maybe someone else is appointed as a IRP. And now I want, because the assets are intermingled, one company is having the immovable property, the other company is having the right to build over there. Or there are investment from one company to the other company. And likewise, there are many n number of issues which are in relation to these two companies or more than two companies. So with that objective, the discretion was given to the insolvency professional to prefer an application to the adjudicating authority to call off all the matter into one jurisdiction. And it was termed as a group insolvency, and it was working the IRP of both entities, or maybe they were common, or if not common, they were directed to work in coordination and cooperation so that the ultimate objective of maximization could be achieved. Now, still, it is premature. The concept is very nice. I'm not against this concept. This is a requirement, because in many of the cases, otherwise the resolution may not be possible if we are working in a different tangent. So concept wise, I am very much aligned with the thought process. My worry is only that not much water has flown in the last 4 years as far as the learning experience is concerned. Government may face challenges. The IBBI may also face challenges in terms of putting these things in terms of regulation. Although I agree, making regulations is always good, but whether those regulations will harm more or will they facilitate more, will only time will tell. Now, my only worry is that, because many things we have seen that until they were defined, I think the situation was far better. The moment they had been defined, the situation is a little different. So my only concern is that. Otherwise, the concept is wonderful,
Right.
No doubt about that.
Right. Moving on to the next, improving recoveries for operational creditors and liquidation. This has been a big concern, wherein the operational creditors have multiple times stated that their recoveries during liquidation have gone down substantially. The current position of law is that the operational creditors are categorized in any other debts and dues, which stands in the 6th place in the waterfall process. Now, what they propose is that all unsecured creditors, whether it is financial creditor, operational creditor, or any government authority, of course, with the exception of workmen and employees, they shall all be treated at an equal footing and equal distribution process under section 53. So they are shifting it to the 4th step in the waterfall. clarity in the treatment of security interest
Hello.
rate.
Ma'am, just to interrupt,
Yes.
the
Yes.
previous points. Is this the matter in the matter of SR Steel? If you should see, the matter was challenged at various levels like NCLT, NCLAT, and Supreme Court. So in the NCLT matter, it was held that the financial creditors have a supremacy over the operational creditors and other government authorities. In the NCLAT, it was all the distribution was done proportionately, treated equally. The financial creditors as well as operational creditors were treated equally. But when the matter was challenged by the financial creditors in the Supreme Court, it was held that the NCLT has erred into the judgment of treating equal, giving equal distribution to FCs as well as OCs. So when
Treating unequals as equal.
Right.
So when Supreme Court has decided that no financial creditors has a supremacy over operational creditors, so law can become enforced when Supreme Court has already decided into this matter?
See, if you ask my view, the power of legislation, I think the legislature has got all the power to amend the law, even against the directions of the Supreme Court also. And that's how the law has been evolving over a period of time. Wherever we have found the gaps, and now also one can say that there is a Vidarbha judgment, and now government is coming out with the rescue that yes, there is a loophole. Maybe the Vidarbha judgment exists, but we have now noted that there is an observation of Supreme Court in this manner, which was not the intent of law. So it is being rectified. So we cannot question and we cannot challenge the mechanism by which the law is made. And definitely the lawmakers had that power that if they think that in their own wisdom, the law is required to be amended to implement as per the spirit with which the law was created, I think they will be well within their right.
So even if the lawmaker make it this as a proposed amendment, and some financial creditors maybe challenge this lawmaking in the Supreme Court, and generally what I suppose is this amendment that is proposed could be 100% is going to be challenged by the financial creditors, because they will not be able to get what they are currently getting.
Excuse me, but if you observe, they are talking about unsecured creditors, not secured financial creditors.
Yeah, ma'am.
So
Exactly.
that's why I know it's a conscious move, I think, is made, because when it is a secured, basically financial institution they are covering. The intention of the law to give preference to FC was to keep in line the credit line open for all SME. Now here the SME argued that we are also financing by providing our services, and if we are at the mercy of FC, then we are not getting treated. So we are also equally unsecured financial creditor, because we have provided our goods and services for which we are not paid. We have provided fund to the company in a kind format. And the unsecured financial creditor has provided fund in a fund format. That is the difference. And looking at that, this is provided. So I think there is a logic, and if there is a challenge, we have to check it. Whatever it happened, challenge, no one can stop the challenge. So let's wait for that.
And so particularly this proposed amendment, this set has challenged the Supreme Court judgment so many times. They've challenged Vidarbha. We'll go to the subsequent one where they've kind of tried to reverse the position in Rainbow Papers as well. We're coming to that. So, of course, still it does not sail through. This remains, the position of law as on date remains. But if it sails through, of course, there will be a lot of change then.
Yeah.
So there will always be pros and cons of each and every action, right? When this section 53 also got notified in the insolvency law, there were many questions, because the previous position of waterfall was entirely different. The government was sitting altogether in a different position. Now government is sitting altogether in a different position. Nobody was able to digest that crown debt will be depreciated in such a fashion. But ultimately we survived, and there are now more than 3-4 Supreme Court judgment on the constitutional validity of Section 53. So there can always be debate whether this move is good or bad. We can definitely make a debate on that. Everybody will have his own view, but yes, that is a proposal that few peoples have made a representation, as Dipti ma'am has rightly mentioned, that there was a representation made from the micro, small, medium segment that we are also contributed to the economy by way of providing these finances, and when it comes to getting our money back in terms of distribution at the time of liquidation, then why we are left in limbo? So we should also be party. At least you bring us at par with the other unsecured creditor, financial creditor, and the operational creditor, and the government authority will now be coming to the parity. That is the thought. How bad it is? Yes, we can certainly make that debate.
No, the clarity or the definition of statutory creditors post rainbow, maybe we'll take care in the recent amendment.
No. Let me take, because you have raised that point. I think
that is just the next slide. If you could allow me to complete that, everybody will get a clarity.
Right, and also the security interest, both together, if you can cover, will be.
Yes. Just for the benefit of all the participants, I'll just take that up before Amit sir, you give your views on it. So like we were discussing, clarity in treatment of security interests created by statutes. So due to the Supreme Court judgment in State Tax Officer versus Rainbow Papers Limited, which stated that the Supreme Court, the central government and state government should be treated as secured creditors, even if the security interest is created by law. What they have proposed here as an amendment is that the debt owed to the central government and state government shall be treated as unsecured creditor, unsecured debt only, irrespective of security interest created by mere operation of law or operation of statute. So just because there is one provision in the law, you cannot state them as secured. However, they have went on to state that only where a security interest is created pursuant to a particular transaction of the central government or state government with the corporate debtor, only then they can be treated as secured creditors. This is to kind of undo the effect of Rainbow Papers Limited judgment.
So absolutely, Jasveen, I think if we read fine words of the Rainbow Paper judgment, my reading is that maybe it has been applied and it has been argued at NCLT level, at NCLAT level, in different matters, and is also continuously also being now argued before even Supreme Court, also quoting the Rainbow Paper judgment in their own manner. Everybody is taking the advantage of the judgment what has been delivered in the Rainbow matter. But as I see the Rainbow Paper, I understand it has to be read in the context in which the judgment appeared, and it is having a very limited role. Yes, that ill effect of that judgment is also obviously required to be cured and taken care by the government, and it has been well captured in the discussion paper as to how the ill effect of Rainbow Paper will be curated, right? I am having no doubt on that. Now, so my reading is, just allow me a minute. So my reading is that if you see why Rainbow Paper judgment survived is primarily because GST law, the liability that arisen was in respect of Gujarat VAT authority, and who challenged this particular point and raised this issue, and Supreme Court accepted that yes, that has to be considered, primarily because GST law is a law which is post insolvency and bankruptcy. There are two non-obstante clauses. One is in section 53 and 238 of the Insolvency and Bankruptcy Code, and the other non-obstante clause sits in the GST law of the maybe what is applicable in Gujarat or maybe universally across the country. Now, Government or the Supreme Court, while doing that interpretation, interpreted that the law which is subsequent to insolvency, while drafting, if it has created a non-obstante clause in their own legislation, then that has to be given weight to. It cannot be ignored. That is the principle of interpretation, and rightly so. If that is the case, then it has to be given, and that effect has been given. Now, if I say that all statutory dues will be put at the same position, my view is negative. Income tax dues will not be following the same position what the GST dues are having. Similarly, Provident Fund, though Provident Fund is altogether a different matter, let's not go into that. So, because there are judgments which is now putting Provident Fund and other dues altogether on a different footing, and they are saying that those funds are not to be touched at all. They are not part of the liquidation state at all. The judgment what recently has been pronounced. So if we limit our discussion to the security interest, I think now what the government is trying to do is whatever ill effect the rainbow judgment has created by saying that only where the security interest is created pursuant to a transaction of central government, state government with the CD. Only in those cases, you will be considered as a secured creditor. Now, for the moment, my worry is where if for a moment I take this also as a situation, what is the meaning of a transaction? If let's say I have sold certain goods from A entity, ABC Limited has sold goods worth rupees 100 crore to PQR, and GST liability of 18 crore has been created. Is it a transaction with the government, or is it a transaction between ABC and PQR? I am yet not able to decode this particular terminology. Unless and until the fine readings are coming, I am not able to understand as to what is the meaning. Now, second point, if I say that security interest has to be considered as it survives, that there will be two kinds of security interest. One, security interest that is created by virtue of instrument, like maybe it is a mortgage deed, maybe it is a memorandum of entry, maybe it is a hypothecation. So there is an underlying asset and a security interest is created thereupon. Now, by operation of law, if I am creating a security interest, for the moment, just for argument's sake, if I take that security interest will be taken cognizance of. Now, how the relinquishment will happen under 52? What will be the mode of relinquishment? Let us assume that by every secured creditor has been given a mandate under 52, a timeline has been given that you have to relinquish. If I am a secured creditor, I have a property with me. I have a 100 crore asset with me, which I relinquish in favor of a liquidator so that he can go ahead with the sale thereof and allow me the sitting at a level 2 in the waterfall mechanism under section 53. Now, if I consider that security interest by operation of law is to be considered, what will be the mode of relinquishment? I am not yet able to understand. Or simply a letter that I relinquish my interest, then what you are giving? By relinquishment, your position was getting uplifted because you were contributing to the asset, to the liquidation state, because otherwise you were taking that asset out of liquidation and realizing it to your own realizable money. But by doing this process where you don't have anything underlying, what benefit? Whether it will sustain over a period of time is a matter of question. That is my initial thought. I am not able to understand how this practically will be implemented, the security interest part. Now now you come back to
I had the same question which you answered, that the thin line between the consensual transaction between parties and security interest created through operation of statute. It is very, very not so always clear, especially, I don't know, when you have a sales tax loan or kind of this thing deferral over a period If it is created through statute, it is still possible that he is a secured creditor, even though he may be a statutory creditor.
So security interest is not a concept only in GST law. It is a concept in many laws. Income tax law 178 also recognizes. Provident fund law recognizes. There are n number of other laws also where the custom law is there, where the security interest is created. So that is for protecting the interest under that very law. To me, rainbow judgment to that extent is faulty and needs to be cured by way of necessary amendment therein. Whether this amendment will suffice for that matter or not, because this part, what I read just now, that security interest is created pursuant to a transaction of CGSG with CD, I am not very comfortable, because unless we read between the line as to what the government actually brings out as an amendment in the law, I think till that time we may keep on debating as to what are the permutation combinations which will be overseen over a period of time.
Hi Amit. Hi Amit, this is Ashish.
Yeah, Ashish.
So good to see you.
Yeah.
So I have a question here. So good afternoon, madam.
Good afternoon.
Yeah. So Dipti madam, good afternoon.
Good afternoon. How are you?
I'm good. Good to see you. You must have known by now I have started attending the webinar. So
Yeah.
so my team member Kinshuk is also attending your webinar.
Yeah,
So
thank you.
Amit,
Thank
I have
you.
a question
Yeah.
on this judgment which you are referring. I think I just wanted to understand the treatment of the income tax dues in case of the IBC proceedings and the company in liquidation. So I would also like you to throw upon some light on the latest latest judgment, wherein it was actually ruled that income tax dues will be considered at par with the secured creditors due.
So
And
Ashish,
I would
Ashish,
also.
I understood your
Just
point.
my last question. Yeah, hear me out. Just my last question. Would the position be different in case I have obtained 281 certificate from Income Tax Authority? So these are my 3 questions.
So I'll answer in very, very brief, because Jasveen is looking at me that I should not eat out more time, because Dipti ma'am has given a mandate to close at 6:30. But nevertheless, I will do that. Ashish, the point is that is what we have been discussing. The rainbow judgment, many of the professionals and the advocate have been taking the advantage of rainbow paper in their own manner. Now, and that judgment is being quoted by both of the side of the people, and they are taking the best advantage wherever it is possible. So there are many matters where I have also heard that order is being passed that because of in the backdrop of the rainbow judgment, the income tax dues will also sit at par with the secured creditor. That is the treatment that is being done. To my mind, that is the reason what I just now stated, that the position of security interest in GST law vis-a-vis the other laws is different. Because of the GST law having a enactment date post insolvency and bankruptcy, I believe Supreme Court has relied on that rule of interpretation and has given a sustainability to the GST dues at par with the secured creditor. But other dues, whether they will sustain over a period of time or not, I am having my own doubt. It will not pass the muster test of the principle of interpretation. So they are going to ultimately be decided that no, you cannot claim the similar position. Now you are asking ki what is the position? So the position is very clear. If you see the 53 waterfall, there are 8 different layers. So income tax dues will sit at a layer 6. And if you are able to have the money, liquidation state is able to realize the money which is sufficient to reach to the level 6, then only you will be, income tax dues will be allowed to be paid. Otherwise not. They cannot claim a priority. That is very clear. Even if 281 certificate, if you are saying I'm not understanding from which background you are asking that question. 281, if I understand correctly, is with regard to when we go for sale of any assets, then income tax authority is required to give a certificate under section 281, or we are required to obtain the certificate, and it ensures that the income tax liabilities will be paid off, or there is sufficient money, which is a similar provision to section 178 when we talk about the liquidation of companies, that the income tax department want to ensure that you have a sufficient money to take care of the dues of the income tax. Then they allow you the liquidation process. So I think it is not going to change anything, whether you are having 281 or not. That's my view. And maybe I'll correct you maybe separately after this session is done. So we can discuss more on these judgments also, and I can share by a couple of other views also.
Sure, thank you.
So
So
Jasveen,
it can be said that it is as on today, it can be, but still the chances that this statutory dues, except GST, can be questionable whether it can be secured. That is the view, but yes, as on today, we
Until-
cannot confirmly say that. It depends on-
prior to Rainbow, no one ever thought of that these things will sit at a level of a secured creditor, right?
Absolutely.
After Rainbow, now we are talking, right? So tomorrow,
Right.
what will happen? What logic someone will carve out in a Supreme Court tomorrow for the income tax dues also, you don't know. Now, until we have explored that
And
territory, we are.
That's why IBPI is proposing this. That's very clearly central government. That's so to the central and state government. So
No,
even
but
here-
the way it is worded, I am having my own doubt. That is already I have flagged that is created pursuant to a transaction is not very clean to me. I need to digest completely before giving a reaction to that, whether it will help or not.
Yes.
But the biggest problem, madam, is that the official liquidators are actually holding up the distribution because of this judgment and saying that income tax dues are to be considered at par with the secured creditor. That is the biggest problem.
That happens.
Yeah.
That happens with the system. Now, unless and until you get some favorable ruling from somewhere, right? This will always be in the debate. Today, it is a debate because after Rainbow, it has opened up. And it will continue until it reaches to the apex court, and apex court decides no.
Again, clarify.
Yeah, income tax dues will sit in a different position, and GST dues will be sitting in a different position. Then only it will clarify. Otherwise, always the authority will always claim. Otherwise, they have a duty also, na? Because they are pro-revenue. Tomorrow, they will be questioned in the AG audit also as to why you have not taken necessary steps to protect your revenue.
Any
So-
representation has been made to IBPI for this clarification?
I think you are the right person to make.
That is why because I wanted to actually create in some other matter also some precedence.
Yeah,
So
yeah,
that is
sure,
why.
you should know because you are.
Representations are to the best of my understanding through associations are already made to give a clarity, but I think IBPI will not be in a position to give a clarity because it's a matter of legislation.
Right.
So Supreme Court has observed something in some of the matters. So it will be difficult for.
Right.
Sure.
But yes, concern may be taken note of by IBPI, and they can make, I believe, because of those concerns only, this amendment is also being proposed. Otherwise, we could not have seen the light of the discussion.
And whether IBPI has commented also that it will have a impact and all that openly in a public forum also. They
Yes,
are knowing that because what BLRC report states and how it is turning out. So
in a roundtable discussion,
proposed amendment, as you rightly mentioned, that's why this proposed amendment they are clarifying this.
in roundtable discussion also, when we were there, I believe you were also participating. The chairman was also there. He categorically mentioned that yes, we are aware about the concerns being raised by the stakeholder in this regard, and we will definitely do the needful, whatever is required to overcome this ill effect. So I'm sure only thing is that if the interest of a stakeholder is being protected by these wordings, it is okay. Otherwise, we might, although the time is over, but still we can give a our suggestion to the IBBI. They will always consider, not an issue. Yeah,
Right.
Jasveen, please go ahead.
Yeah.
Yes. Disclosure of valuation estimates of the assets in the information memorandum, just to ensure more transparency and ensure that better resolution plans come up. They've proposed to make an amendment to section 29 to include that the information memorandum shall contain an estimate of the valuation of the assets of the corporate debtor.
I think it's a welcome move. Why
Right.
it was stopped? Because originally, if you see, I started practice in 2016, first batch. So Dipti ma'am will agree. There was no such restriction, and the information memorandum which were issued in late part of 2016 and early part of 2017, they were including the information memorandum was including this detail. But later on, amendment came and this was stopped. That people will misuse this information and they will give the resolution plan only surrounding to that value. With that objective, the valuation part was removed from the information memorandum. Now again, that is brought back, I think, with a different objective to make the process little more transparent.
Transparent,
Right.
And because I think somewhere they are moving towards a model of a Swiss challenge ultimately.
Yes.
Because that is in the back of the mind. Maybe it is difficult to implement in one go, but they are thinking that when I am prepared for a Swiss challenge, then let it be open and transparent to everybody so that we get a maximization in value. And I think the future lies there only. Unless you come out with the Swiss challenge mechanism in the entire process, maybe I agree the challenges are there, but still, I think with that objective, this is a one step in that direction only, that they want to bring transparency.
Right.
Yeah.
Moving on, certain category of operational creditors to honor the agreement with the corporate debtor for the remaining useful life of the agreement. So as on date, we have in place a mandate by the under the IBC to provide essential services as well as ensuring that the corporate debtor is a going concern. However, now they propose to extend it to even after the approval of the resolution plan. So under section 31, an explanation is proposed to be added to provide and clarify that even after the approval of the resolution plan, unless the corporate debtor fails to fulfill the obligations, it shall be a mandate to continue to honor the arrangement and the agreements. This is also in regard the licenses that were given to the corporate debtor. This is to ensure that the resolution plan is implemented in a smooth manner and the corporate debtor can then come back to its feet.
I think it's a very obvious amendment.
Right. Protection of a resolution applicant post implementation of the resolution plan concerning the civil liabilities. This has been discussed several times. As on date, we have a provision under section 31 which says that an approved resolution plan shall be binding upon all. However, now they propose to clarify that post approval of the resolution plan, no proceedings regarding the claim arising before the commencement of the CIRP can sustain, and all such claims shall stand extinguished. This has been discussed several times in multiple judgments by the Supreme Court as well, that whenever a resolution plan is approved, the corporate debtor should be given an opportunity to start from a fresh slate.
Yeah, I think Ashish has some query. Yeah.
Yeah. So just on the protection of the assets during the CIRP, I have just a small clarification to obtain over this webinar. So it actually, if you see, the resolution professional and IRP both are duty bound to act in an interest wherein their prime importance should be on the protection of the assets. So my question is, if a CIRP, if the resolution professional has been appointed, what would be the position of the nominated directors on the company whose holding company's insolvency petition has been approved. For example, A is a joint venture company between B and C. B has been notified as a insolvency. B's petition has been admitted, and there are certain directors of representing B on the A company. And in this case, when IRP or the resolution professional has been appointed, all the powers and management and affairs of the A would vest with the RP. So how this RP will act, or maybe would he recognize the nominee director on the principal company, or he would be treated as maybe a board representative of the company whose insolvency petition has been admitted?
So Ashish, I think law is very clear. From the commencement of corporate insolvency resolution process, the power of the board gets suspended. Mind the word, it is power, it is not the director. So board continues to exist, director continues on the board, only he is not having any power to exercise. On the same time, whatever duties, whatever obligations that director has, those duties, obligations continues. Having said so, now how the things will be performed and what is the scheme in which the CIRP process work? What is the expectation? So if I am an insolvency professional appointed on that entity A, and I have taken charge as a interim resolution professional, so, and let us say you and two other people are the director and you are nominee director. So for me, the expectation from you as well as the other director is to cooperate. So that is your duty also as a nominee director, to first and foremost cooperate with me, so that I am there not as an alien, I am there to help the company to revive. The objective is not to recover the money. The objective is very clear, that I am appointed to find out a resolution plan to revive a company, and if ultimately we are not able to find out any resolution, the company will go for liquidation, and in that case also the maximization of value of all stakeholders has to be taken care of. Now, the point that you are saying from the standpoint of a nominee director, so whether a nominee will be replaced or not, whether new person will be appointed or not, these are all questions which you might be having in your mind, but there is no straight cut answer. It is a discretion of a IRP or RP, at what stage he decides that he want to replace the nominee over the other entity in which you are appointed as a, in which the CIRP process has started, right? All these questions are more like a situation and fact based, and in each different situation there is nothing in law which mandates that no, like as regards the powers of board is concerned, that law is very clear, but regarding the other things the law is not very clear, and the discretion has been given to the resolution professional. To the prime objective is that to keep the company in a going concern model and to maximize the value whatever he can through the resolution plan. That's the objective. But if you ask me precisely that nominee director will have any specific duty, so in general, what section 166 talks about, what fiduciary duty, what common law duty he is having, he should abide by those duties unless and until he is being replaced by some other nominee by the IRP itself. But
thank you, Amit. So if I've understood correctly, and if I've taken a stand that it is the prerogative of the RP or IRP to comment on the nominee director, is that the correct stand?
To comment on the nominee director
position of the director, whether he wants to continue with those director, replace those director, etc., etc.
So by default, we should presume that unless we receive any communication further,
perfect,
we have to continue. We
Thank
have
you.
to continue to perform whatever I am obligated to.
And Ashish, generally, when this kind of decision in so IP or IRP take, they take into confidence COC also, because it's a thing, big
Yeah.
thing. And so far possible, they continue with the existing arrangement. So far, they perform the duty, because nominee directors were earlier also performing duty. They have to continue performing duty. And if there is no any problem, then generally the same arrangements carry on. That's
Correct.
Sure, madam. Thank you. Thank you, Amit, and thank you, madam.
Thanks. Yeah, Jasveen.
Yes. Moving on, clarity on competition of voting rights and treatment of the abstention. So as on date, the voting share is calculated as a percentage of the total financial debt owed by the corporate debtor. They propose to add an amendment and amend section 5 subsection 28 to state that voting share should be computed as a percentage or in relation to the debt owed only to the members of the COC who are eligible to vote as per section 21, which means related creditors would be eliminated from this. Further, they state that to prevent the members from abstaining from voting, the voting threshold for major decisions would be 2/3 of the COC members who are present plus voting at the meeting, and the requirement of voting share at least 51% would remain.
Yeah, I think it is to overcome a couple of concerns raised by Apex Court in a few of the matters where the voting percentage, what has happened in cases where the people have not voted, they have been, and you have considered only 66% of the person present and voting. For that matter, to overcome that, I believe this additional vote share of 51% or more of the total voting share has been further added.
Right, and main the presence of COC members who are voting.
Present and voting, this
Present
clarification.
and voting. Yeah.
Because I am facing the same, so just that's why immediately
Correct.
present
Right.
and voting, it's clarification. And of course, by that they added voting share by at least 51% of more total voting shares. It should
Right.
not be present and voting 2-3 people. I think
I
this
think that is what the position got settled in 2017, way back in Apex Court. Which matter I'm not able to recall, but yes, this was a very first judgment where the I think SR matter only 2017 or 2018, where this was clarified that present and voting only will be considered. Though, but now the law is being amended to bring I think better clarity instead of relying only on the judgments.
But Amit, that decided case is there, but if you see the law, majority are doing that. Present and voting is not a voting. Entire people, the entire present, not necessarily they are present. But who are entitled to voting, that voting result is counted for percentage.
Yeah, that's true, because nobody wants to take that chance on the basis of the judgment what has been derived. Because that is not the law, that is the view or
Right.
observation
In particular case.
in a
Right.
particular- that cannot become the law. So everybody, even if you ask me also, so we have been following the same thing, and you must also.
Yeah, I am also facing the same, the what is there. So this will be really a relief.
Right, that is the intention of the proposed amendment.
See, these are the bottlenecks where the your matter, because of these things, if a company is going to the liquidation, where the biggest change will happen now, means I keep on saying this, although the attempt has also been made, when the code of conduct will come for the creditors. Unfortunately, the discussions have been made many times, but we have not been able to, despite notification, we are not able to implement the same. Unless you, because one of the most important pillar of the insolvency is committee of creditor, on which your entire, means your insolvency law is based on the one fact or one recommendation of BLRC, that it is the creditor in control model, from debtor in control model. And now my creditor itself is not having any code of conduct to define and run the process. I'm having my own doubts why it has not happened in the last 6.5 years of time, right? Unless we do that, I think not much is required. Again, I'm saying I'm not very critical about the amendment. I don't think that these all amendments are required. Only basics are required, that you rectify the basic things in the system, you bring out and implement the code of conduct, your half of the problem will be solved. Majority of the cases, delays are happening because of the inactions of the committee of creditor in that meeting itself. Your timeline of 48 hours for completing any particular task or completing the voting is never completed. Invariably, in all cases, 1 week after the confirmation comes that now you can start the voting. And then after also, he will ask you 2-time adjournment or extension of the time. And in none of the COC meeting in last 6 years of time, I have seen that any of the representative of the financial creditor comes with the authority that I am authority, I will take a decision.
Absolutely.
The authority is always taken at a back end. So if these kind of things continue, so we cannot avoid the delay, what is happening. And all these things, the discussion paper is based on one fundamental premise, that it is to avoid the delay, to expedite the process, to expedite the resolution, to fast forward everything. We are bringing a concept of, again, the fast track insolvency. Or a long track insolvency, we are not able to implement in the particular given frame of time. And now we are focusing again on the fast track insolvency. Do something what is achievable. Now, if we set the fundamental right, I think we'll be able to achieve. Otherwise, we are distracted. Now, you bring only those amendments which are necessary to tweak and bring the code for these stakeholders. Like you have brought the code for insolvency professional, all right. You are taking actions, all right. But you should at the same time also bring the code for the other stakeholder also, so that harmony is there. Otherwise, today, there is no harmony. We are under pressure to perform, but what about the other stakeholder? For other stakeholder mistake, again, the punishment is being given to whom? The insolvency professional. You see the orders, what had been passed in the last 1 year of time. Anyways, I'm just
I'll just go ahead.
Yeah, please.
Incentivizing interim finance providers. So to encourage the provision of interim finance during the CIRP, they have proposed an amendment wherein they state that the interim finance provider shall become the non-voting members of the COC. This is just to keep them informed about the proceedings that are carried out during the CIRP.
Which is okay. Their interest is protected, so they are not required to be participating in that voting.
Right. Appointment of administrator by central government. So it proposes that in certain cases wherein a lot of public interest is involved for particular categories of corporate debtors, the central government should be given a right to appoint an administrator. This is to ensure that the CIRP process is a little more quick as compared to the timelines that are being followed now.
Yeah, this is required, and I am also privy to some 4 or 5 cases which are cases of a fraud. And interestingly, unless and until you have a provision, now we are running from pillar to post with the adjudicating authority to declare those processes as non fit for CIRP cases, where there is nothing left, where there is a case of a fraud. What resolution you will be trying to achieve? You are only wasting a time of a insolvency professional. You are wasting a time of a adjudicating mechanism. You are burdening each and every stakeholder. So it is fit case that we identify the mechanism by which we will be able to identify those cases, and we will put them into the different radar. Maybe I'll say one step forward, that these cases should be put out of the CIRP, and the investigation, if at all is required, maybe CBI, SFIO or whatever, if the trigger is happening, you refer those matters. You cannot resolve these matters by CIRP. I am aware in many of the cases, the CIRP has been conducted, CIRP ended in a liquidation, and the companies have been closed. without initiating any fraudulent action. So the promoter or the person who has been culprit, he has got encouraged, that he has been successful by CIRP process, that he has got a bailout. I think that should not be the intent. There should be necessary plugin, and at the same time the IRP should not be punished because of running, because he has to even run the process on his own cost. I know a couple of IRPs who are running the process for the last 4 years at their own cost, not a single penny, and they are not able, when they submit the resignation to the adjudicating authority, there is no one. Adjudicating authority is not accepting. They say, "Ki, don't know, you cannot run out from the process. You have to perform." But from where to perform is a question. He is not given any kitty. He is not having any money. So in those cases, I am saying, I am suggesting, I have already suggested also one step forward, not only the administrator, there should be a mechanism to find out the cases which are fit for being referred to the agencies for investigation. And CIRP should be terminated. Matter should be taken back from insolvency professional and should be handed over to some investigating agency. That's it.
Okay. Yeah. Go ahead.
Amit, I have a question on this appointment of administrator, a small question. So if suppose in a scenario where administrator has been appointed to run the CIRP, in that case, all the powers and the appointment of RPs and IRPs are done away with, right? They are no more in the process, or
Now,
it's a
Ashish,
parallel process.
Ashish, I believe we have to wait, because exactly what they mean by administrator, because in many of the matters where the SEBI has been regulator, the IRP are appointed as an administrator, though they are named as an administrator, but insolvency professional only has been nominated as an administrator in few matters, which I recall. I think in one of the first financial intermediary matter, for which the law also was amended to include and do that.
DHFL.
DHFL. Yeah. In that matter, they have appointed someone else as the administrator. But for the SEBI being regulator, I believe here the DHFL model they are trying to bring in for the purpose of bringing it into the framework of law. That is what appears.
So in Reliance Capital, the IRP has been nominated as administrator, right?
Yes.
Okay, understood.
So,
Dipti madam, I think this 1 hour webinar would not suffice. You need to do a workshop for a day.
Ashish, IBC is such a law that there is never ending questions in this.
we have,
And IBC
So
is very,
ask 10 days,
yeah,
10 days question will start and answers will keep on coming.
I know.
And then 10 more questions will be raised in next seminar. This is the law of that nature.
And this subject is very close to the heart of many people, huh?
in 2017, Ashish, me, I think Dipti ma'am was also there. We did one research program for 3 days continuously. March, I think 14, 15, 16, 2017, I think when the law was just a very baby.
Okay.
And for 3 days, but we were not able to complete the discussion on many of the aspects. So your point is valid, but yes, these are the programs where we get a spark and we get the exchange of the thoughts, but definitely.
Look forward to many such workshop for maybe 1 or 2 days so that I can also participate.
Yeah, surely we'll think of. Okay, Jasveen.
Another amendment is proposed amendment is power to exempt a class of corporate debtors from the provisions of the code. So like they say that section 462 of the Companies Act also has a power, gives the power to the central government to provide exemptions to certain categories. They wish to implement or make a provision in that regard in the IBC as well, wherein they state that the central government should be given a power to exempt certain class or classes of debtors from the applicability of provisions of the code, and also apply the provisions with certain exemptions, modifications, or adaptations. This is also specifically because of the changes they propose to make in the real estate sector as regards the CIRP of such corporate debtors is concerned. So this would enable them to do that.
And thankfully, this has been one of my suggestions, not from today, but from 2018. I have been consistently advocating this thought that real estate is not a subject of insolvency. When you have already enacted RERA separately, why don't you strengthen RERA for the purpose of enforcing the rights of home buyers at a separate forum? Now, if you have any shortfall, you amend the RERA and bring it to the enforcement level legislation instead of burdening the biggest mistake. To be very honest, nothing against anybody, but the turning point of the insolvency law, I consider, was the consideration of home buyers as a financial creditor based on the judgment of Apex Code, because it has cluttered your adjudicating authority. The matters, the number of cases which are now pending before the adjudicating authority are majority in number of the real estate. Now, if you take out those numbers from the adjudicating authority, I think your adjudicating authority will become leaner and thinner. And you know there is no absolutely solution also in the case of real estate home buyers cases. Now, maybe few here and there cases, like in some of the matter you have mandated some agency for coming forward as a bailout and do something. That's not possible in each and every case. We can do experimentation, but to be honest, I think insolvency law should be kept for the different purpose, and the real estate resolution should be kept as a separate purpose. So I am so very happy that government has listened and they are coming out with this carve out for certainly very good reason.
Right. Moving on, certain proposed amendments to individual insolvency. The vision that is kept in mind is supported by the Supreme Court judgment in Lalit Kumar Jain, where they had observed that the personal guarantor is a separate class of individuals owing to their proximity with the corporate debtors and the complex nature of cases. So what has been observed is that certain personal guarantors have been misusing the procedure of initiation of the individual insolvency process against the personal guarantors, just to take advantage of the interim moratorium provision. So what they propose is that section 96 would become inapplicable, that is, of the interim moratorium will become inapplicable to personal guarantors specifically. Second, they state that section 97 should be amended to provide that there should be a common resolution professional to carry out the process of individual insolvency and CIRP that are taking place simultaneously, so that it ensures better coordination and cooperation between these two processes. Further, under section 106, as on date, the resolution professional has a discretion whether to call a meeting of creditors or not during the process of individual insolvency. However, as regards personal guarantors proceedings is concerned, they have proposed that section 106 shall make it mandatory to call the meeting of creditors, and there should be no discretion given to the resolution professional in this regard.
So Jasveen, I'll take 2 minutes because this is very important amendment and maybe everybody is not aware about the individual insolvency process. So let us take a case that ABC Limited is a corporate debtor, and State Bank of India has given a loan of 100 crore to ABC Limited, wherein Mr. A, who is the promoter director, has given a guarantee for 100 crore. ABC Limited went into CIRP. A resolution plan was submitted, and State Bank of India could recover 50 crore against 100 crore liability. Now, State Bank of India decided that balance 50 crore has to be recovered. What is the option available? Prior to 1/12/20 the why 1/12/2019? Because PG to CD provision got notified on 1/12/2019, 3 years after the implementation of insolvency law. Why it was implemented and what is the background? Because in India, if you understand, the enforcement of security interest, where you have a asset in your possession or you have a document in your possession. In case of ABC Limited, what must be the security? That ABC Limited entire assets must have been mortgaged to State Bank of India. They must have title deeds. They must have the hypothecation deed in respect of stock. Their State Bank of India has suffered a lot in terms of enforcement of that security. That's why they have opted for this resolution, and they could receive only part of the money. They could not realize full money. And that's true. It is because of the insolvency resolution process they could recover. You just imagine about a situation prior to 2016 when they had to go for SARFACI, or they have to go for DRT or for any other civil remedy for enforcement thereof. So in India, nutshell, the enforcement of security interest or enforcement of a decree in case of realization of any asset is very, very challenging. That is the biggest bottleneck for a country like India. And that's one reason where we are lacking, despite having insolvency law in force. Because of lacking on that particular part, still we are not able to achieve the full marks in the ease of doing business index when we talk about, right? So that is one gray area. Why I am giving this background? That this subject has been into debate from very beginning when this implementation came. The idea was that by threatening a person that you will be declared insolvent, you will be able to recover some money, some more money. Because the belief of a banker was that maybe the company ABC Limited has gone sick, but the promoters have not become sick. Promoters have become fat day by day. And they must be having some personal assets in their own name, which if liquidated will help the banker to realize the money. And that's the background. They thought that they will be implementing individual insolvency for PG to CD cases. And they created beautifully a carve out in the insolvency law, which was originally not there. We all will agree the matter went up to Supreme Court, and in Lalit Kumar Jain versus Union of India, Supreme Court decided for the favor that the law is constitutional, right? But issue remains there. Issue remains there because there is a one important provision from where the threatening is coming. Let us understand, when the individual insolvency has been invoked, what will happen next? There are three processes in the individual insolvency which runs. One is the fresh start process, which is for very small individuals, right? Which we are not talking about. Let us not discuss that. Second is the individual insolvency resolution. And third is the bankruptcy. So individual insolvency resolution is something which is replica to corporate insolvency resolution. What is there? CIRP in the case of corporate is the individual insolvency resolution in the case of an individual. Now, what happens in the case of CIRP? If a resolution plan does not come, then it leads to compulsory liquidation. Logically, if an individual insolvency fails, then it should also lead to compulsory bankruptcy, but it is not happening.
Yes.
Law is that it gives only a right to debtor or creditor to initiate bankruptcy, but bankruptcy is not mandatory. Now government is again, because whosoever has suggested at that point of time that if you initiate this process, this will work. Now in individual insolvency resolution, what is the idea? Idea is that the same person, Mr. A, if he is having, let's say, assets worth rupees 10 crore, he will come out with a repayment plan and submit it to the adjudicating authority, saying that against the liability of 50 crore, I will pay only 10 crore. And repayment plan is approved. It gives a peace of mind to Mr. A that he is relieved from the insolvency tag. At the same time, it gives some money to a State Bank of India without much of the hassles. They have just initiated the individual insolvency resolution process, and the repayment plan got approved, which is the resolution plan in the case of CIRP, is a repayment plan nomenclated in the case of individual, and you are getting your money back. But in majority of the cases, if you talk about, there are some 1,500 cases which are filed in respect of individual insolvency, out of which I think only 200 odd cases have been filed by the debtor himself. Remaining 1,400 cases have been filed by the financial creditor. But what is the result? Have we been able to resolve any single individual insolvency till date? We are not. Has any single case of bankruptcy being initiated in last 2019 to 2022, 3.5 years is now going to over. We have not been successful in any single case I am talking about. Now government is saying, we let us make 3 amendments. One amendment, they are saying that 96. Now there is one more unique provision in the case of individual insolvency. Moratorium we are aware, but moratorium is starting from the time of admission of your CIRP. Whereas in case of individual, section 96 says that interim moratorium will also be there. Interim moratorium will start from the time of making an application. The moment you file the application to adjudicating authority, your moratorium will start. Government is saying this provision is being misused by many of the debtors to benefit to them, and they are siphoning that asset to their advantage. I have a little doubt on this, whether this will lead to any bigger success. Whosoever is in this process, if he had to siphon that asset, he must have done much before the CIRP has started, or during the course the CIRP has started. He'll not wait till the time of initiation of individual insolvency, right? So this 96 amendment making it inapplicable to PG, to me it is only eyewash. It is not going to help, but yes, government is intending, they may do so. But I'm not hopeful on any bigger resolution coming out of that. Now there is one more restriction. 97 brings a restriction that the person who is a RP of a CIRP cannot be appointed as a RP of an individual.
Right.
Now they are saying, no, you can appoint, because they are thinking that the one person who is there in the CIRP process also, and who is there in the individual insolvency also, though the purpose are different, but he'll be in a better position to run the both process simultaneously. I am okay with that, and I understand, yes, there is a great favor by doing so. So this proposal is acceptable. Now, third proposal, they are saying 106 is required to be amended so that meeting of creditor is compulsory for PG to CD, because there is no concept of COC in the case of individual insolvency. So they are bringing it up parity so that it runs in a more transparent manner. I am okay with this also, because individual insolvency cases majority also, the creditor had a discretion to approve certain processes. So they are invariably doing that. If I talk about me or anybody, I think invariably in all cases we are doing so. There is one more amendment which is being proposed, is that after a resolution professional submits a report.
Sir, I'm just taking that up in the next
He's
slide.
taking that, Amit.
Just give me a moment.
And Amit, majority are IPs only. What we have audience, all majority are IPs and lawyers.
Unfortunately, sir, we had only conducted a webinar on individual insolvency, where we had taken the entire resolution process as well as bankruptcy. So we have a separate series of webinar for that.
Great.
Right.
Right.
Because now 15 minutes left, 10 more slides. Jasveen, you have to rush.
Yes, ma'am. So section 1, they propose to amend section 106 again to provide that where the individual has not submitted the repayment plan within the stipulated time, the RP would be required to submit a report to the adjudicating authority stating the same and for the termination of the insolvency resolution process. Further, they state that on the basis of when such a report is filed, the creditors may be granted the right to file for bankruptcy of the debtor.
So I am having my own doubt why this separate carve out is required. This is already there. The enablement is already there. If you are saying that failure of individual insolvency will lead to bankruptcy, then that's a different issue. But the wordings are not in the discussion paper like that it is going to be compulsory, right?
Right.
It is an option still. Still, it is an option whether the debtor or creditor wants to file a bankruptcy or not. Today also the position is same. I'm not able to understand what is the objective behind making this particular change. That is what I wanted to flag. I am not completely in sync with what the government has proposed. Either I am something missing or government has missed out something, because in bankruptcy also, even if you initiate a bankruptcy is a very noble concept. In India, we have a taboo that the person is a bankrupt, whereas worldwide it has been used as a laundering mechanism where you do the crime, or where you do the, not crime is not the right word, where you do the business, you fail and you come again and you again start your life by way of declaring yourself as a bankrupt and freeing yourself from the liability. Right?
Yeah, Amit, we have to stop.
Yeah.
Okay. To fill in another loophole, they have added, they proposed to add a provision regarding addressing fraudulent transactions by individuals that was missed out in the original law as it is drafted. Further, they wish to make an amendment to state that moratorium for the personal guarantors shall not cover the avoidance action proceedings that are initiated during the CIRP. So they're keeping this out of the ambit of moratorium and not protecting the personal guarantors from it.
Right.
Recasting the liquidation process, the set of first is the direct dissolution of the corporate debtor. This has been happening in practice where it is not advantageous to conduct an entire liquidation process and then dissolve the company. There have been situations where the adjudicating authority has directly passed the order for dissolution of the corporate debtor. However, there is no enabling provision by law for doing the same. Therefore, they propose to make an amendment to state that the COC can request the adjudicating authority to directly dissolve the corporate debtor if conducting liquidation process is not feasible or beneficial. However, it is the discretion of the adjudicating authority whether to allow it or not.
But it has to be used with very caution.
Yes.
Yeah, but at least this option is good, honestly.
Yes.
Option is good. Yeah.
Eliminating duplication of activities between CIRP and liquidation, a very welcome amendment that they wish to make is that there are certain processes such as verification of claims, calling of fresh claims, etc., that are duplicated as regards CIRP and liquidation process. So now what they state is they wish to omit section 38 to 42, which talk about considering calling of claims and verification of claims during liquidation and the requirement to invite fresh claims. Now the liquidator would be required only to maintain a list of creditors during the liquidation process if these amendments sail through. Second is they should the process of carrying out an entire verification to identify and trace avoidable transaction, they wish to substitute it to empower the liquidator only to continue with the proceedings that had been going on already during the CIRP process. Further, there is no obligation on the liquidator to make an entire investigation again during liquidation. They just have been given a power to initiate the fresh proceedings as and when they come across any particular transaction or avoidable transaction during the conduct of the liquidation. This is with the clear intent of saving time. Role of creditors during liquidation process, there is no mandate as on date of a committee of creditors during liquidation. the COC becomes functus officio upon the passing of the liquidation order. Now they propose to consider the COC should be there in place to supervise and support the liquidator and to take commercial decisions or decisions requiring commercial wisdom. The composition of the COC would be more broad-based and it would be as specified by IBPI. Further, they state that in liquidation, the COC may take all decisions with a simple majority of 51% or more. We'll have to see how this gets implemented as by way of an amendment.
Just a quick view of Dipti ma'am, what is your thought on this COC concept bringing in liquidation?
It's okay for me, honestly speaking, because in liquidation, at least if there is a transparency, because otherwise also IP keep a transparency of decision taken and the actions taken and all the movements happening. Only thing that is that the power in the thing, the quick action which is required should not be restricted. Otherwise, it's okay. I think otherwise also all RP liquidator who take action keep acquainted.
The consultation committee is already there. So,
Right.
Yeah. And there should be reasonable, meeting with reasonable gap. That should be the transparency. I accept this. This should be required. It will reduce litigation and misunderstanding between RP and stakeholder.
Right.
Just to keep my understanding right, the 66% to remove the liquidator is still there, right? The COC has to have 66% in case they want to replace the liquidator.
We're coming to that, sir. We're coming to that.
Oh,
Replacement of liquidator. So they propose to make an amendment to say that if the resolution professional is being replaced, and if the COC says that by way of a 66% vote that the resolution profession should not become a liquidator, there should be an amendment enabling provision to do that. Second, they also propose to make an amendment to state that the committee of creditors can replace the liquidator at any time by a 66% vote. This was not there in the liquidation process. COC was 66% was in the resolution profession in the CIRP process.
So here to be noted that they are telling replacement power of liquidator is with COC. So in liquidation, we have consultation committee.
Right.
They are writing COC. So they are giving power to COC, which was
so now
there.
that is what I am saying now, Dipti ma'am, they are bringing a concept of COC in the liquidation also, as far as the other action now, because what has been the experience, the delays majority of the time are happening from the committee of creditors side, right? Now in liquidation, again, we'll be having a same choking kind of situation where you will not be able to perform, and giving a tool of removal of a liquidator by committee of creditor will again put you to a very difficult situation. To me, means I'm not very happy with the situation of power being given to the committee of creditors.
Yeah, power in the sense, again, we have to say that where the approval of that COC, it will be consultation committee or COC. So that consultation committee is named as COC now only, not stakeholder consultation committee.
Yes, post these amendments, there's no concept of consultation committee, it will become a COC.
Because now it is COC, but in that case, now which all matters will be decided by COC is a very crucial. Now we should say that where the law is very clear of sale of asset of e-auction and all that, there we need not take approval. But if you say assignment of debt, which at present is also providing the consultation by consultation committee, is understandable. But for doing the kind of interim dividend, kind of selling asset, transferring, all that power should be allowed to be continued, or kind of specific, very limited things should be given power.
Absolutely.
Yeah.
Stay on continuation of proceedings during liquidation process. We have section 33 subsection 5 that bars institution of suits or legal proceedings, but there is no bar on the continuation of the already set in proceedings. So they wish to amend amend section 33 subsection 5 to prohibit the continuation of any suit or legal proceedings during liquidation. It shall require a specific leave of the adjudicating authority if such proceedings are required to be continued. Further, they state that the pendency of a suit or legal proceeding shall not affect the dissolution of the corporator and shall not cause hindrance to the dissolution. However, the liquidator shall be required to make arrangements, specific arrangements for pursuing suits or proceedings even after the dissolution of the corporator.
Just one small observation on this particular point. When this moratorium concept was brought in, the idea was that during the CIRP process, the moratorium will continue and you will not be able to initiate any suits and continuation of the proceedings will be stopped. Now, idea was that once the company, if not resolved, then it will go into liquidation, and during liquidation period, whatever has not been completed in the legal suits, you will be able to resume. So continuation of the proceeding was not barred. Now you are saying that those proceedings even now cannot be resumed during the liquidation also. So where the remedy will lie? The person.
So, Amit, here it is correcting. The reason being that, see, if it is a financial debt or any recovery, civil suit, if they allow it to continue, the liquidation will end when? You
No,
will not able to.
I
No,
agree.
one second.
I
But
agree.
in that case, there will be never dissolution. So what they are telling, no to continuation. What it says that with the prior approval of A. Now, if we, because certain cases, we tell them to you file the claim. Basically, it is for this, whatever you file the claim. But people don't file the claim and carry on parallel fighting. So parallel in the sense they don't file the claim and they do continue. And if in High Court for years the matter will continue, you will not able to close the case. In that scenario, how to close the
I
company?
agree. Only concern is that because that legal window of
No, it doesn't get closed permanently. See, looking at the situation, if it is fall that no, they deserve something and there is some right, it should continue. A will allow, but if it is just that a financial claim and he's telling no, I should receive that and that, then NCLT will say, boss, you file the claim. RP will take liquidator, and if you have objection on the claim, you come to me, no, I will give the justice. So what, if you remember, BLRC report was telling that it should all be concentrated to NCLT so that you can close it. They are going towards that, and it's a very welcome move according to me. Then only you will lead to dissolution. Otherwise, dissolution will never happen. Entire distribution, and where the money you will bring for fighting that? Who will fight for you?
Problem is, ma'am, that everything cannot be sorted at the level of adjudicating authority because of the complexities involved. Because there will be contracts, there will be which will require.
Exactly. In that scenario, they may allow. And Amit, one thing, this will give some opportunity to liquidator to put their case also. Okay, boss, if it is extended, I don't have money. You allow me, who will going to fight, boss? Who will protect us at that time? I am telling you the most welcome move for IP professionals, and not only for the process also, Amit, because one check bouncing case or forget any small thing, it is pending in High Court for years. You will continue liquidation. You will not able to close it. It is must. This is very much crucial to bring it liquidation to close and dissolution. It's must. I fully go with this.
Move, Jasveen.
Okay. Realization of security interest by secured creditors. They wish to make an amendment to restrict the secured creditors' right to either realize the asset, the security interest, or relinquish it within a stipulated time period. There's no such time period as on date. Further, they state that where the secured creditor does not convey their decision to the liquidator within the time period, it shall be deemed that the relinquishment, that they wish to relinquish the security interest.
It's already there, but now they have reversed the language. Yeah.
It's already there.
No, time period, stipulated time period is what?
It is there, but it is other way that we
Right.
have. But now it is that if you don't give any confirmation, it will be presumed that you have relinquished.
Right, that is the extension. Yes. Exercise of right to relinquish or realize security interest where more than one secured creditors hold the assets pari passu. So under this, they have proposed to provide a presumption that all the assets owned by the corporate debtor shall form a part of the liquidation estate unless all the secured creditors holding a pari passu charge over the particular asset declare that they want to go outside the liquidation process and realize the security. Similar approach would also is also proposed to be adopted for inter se hierarchy of the charges. Role of service provider. This is the last amendment.
One question.
Go back to that. Now here they say that law to provide presumption that all assets owned by CD shall form part of liquidation asset, unless all secured creditors holding pari passu charge over declare to realize. So all together they have to declare,
Yes.
otherwise it will form part. It's a compulsory thing. And similar approach for secure asset in which creditors have inter se hierarchy of charges. So
Okay.
even though they are having hierarchy, but if they are having together, all
Right.
has to decide yes, all has to say no. This is a
It
very
has to be a unanimous decision. Yes.
This was the reason. Otherwise, you cannot move forward. No?
yeah.
One question for me is, with the enhanced role of COC in liquidation, section 35(2) and 35(1), will it be relooked or not? Because 35(2) clearly says that any consultation shall not be binding on the liquidator. Now, is it a consultation or is it a decision by the COC and so?
We'll have to wait for the.
They will change accordingly, yeah, all the things. It's in principle amendment, accordingly they will change it. Yeah.
Right.
Yeah, just.
Role of service providers and other stakeholders. They wish to empower the IBBI to register and regulate specific class of valuers whose services are required during the to carry out the IBC process. Further, the second amendment is that section 219 shall be amended to enable IBBI to issue a show cause notice without any particular investigation or inspection if there is sufficient material on record in the matter. Yes, so with this we come to the end of the presentation.
So good one.
Yo, within time. At least we have reached.
Managed to rush through.
Yeah. Sorry, Amit, I have to stop that time, but bankruptcy was a big topic and I said now I have to. Yeah.
I know. I'm going to complete that part.
Yeah.
I agree.
So thanks, Amit, for all your time. I know you are so busy and that's why delayed. Sorry, participant, but Amit is a very busy person giving lectures and attending webinars everywhere. So we got the time.
As Dipti ma'am is, I'm so always available.
Thanks, everyone. Thank you. We will come after 15 days again with new topic. Thanks a lot. Thanks, Amit. Thank you.
Thank you.
Thank you,
Thank
Jasveen.
you
So much.
Thank you, sir. Thank you so much.